Employment legislation exists to protect both the employer and the employee. Employment legislation covers a number of areas, and the following are the main laws and regulations. The Equality Act of 2010. This Act protects people from discrimination and incorporates the following previous legislation: the Sex Discrimination Act, the Race Relations Act, and the Disability Discrimination Act. Discrimination is classed as direct discrimination, where on racial grounds alone, a person is treated less favourably than others would be treated or is segregated. Indirect discrimination, where a requirement or condition is applied to all people, but it is a requirement A, with which very few people in a smaller racial group can comply, and B, which the employer cannot show is justifiable, and C, which is to the detriment of that person because he or she can't comply with it. Harassment. This is unwanted behaviour linked to discrimination that violates someone's dignity or creates an offensive environment for them. Victimization. This is treating someone unfairly because they have complained about discrimination or harassment. The law also states that the fact that the discrimination was unintentional is not a defence. There are certain types of characteristics that are protected. This means you cannot be discriminated because of them. These include age, being or becoming a transsexual person, being married or in a civil partnership, being pregnant or having a child, disability, race, including colour, nationality, ethnic or national origin, religion, belief, or lack of religion or belief, sex, and sexual orientation. Equality legislation affects buildings where there is general public access and, in order to fulfil their obligations, organisations may, amongst other things, install ramps for wheelchair access, install door opening buttons, install lifts, include braille signage, and fit a disabled toilet with wide access. Some other employment acts include the Employment Rights Act of 1996. This protects against unfair dismissal and redundancy, gives time off for parenting, enforces a minimum wage, and monitors conditions for agency workers. There is also the Employment Relations Act of 2004. This covers union membership and industrial action. The Working Time Regulations of 1998 protect you from being forced to work long hours. You cannot be forced to work more than an average of 48 hours, and this includes overtime. Your employer must maintain records that show the hours you work. They can ask you to opt out of this agreement and ask you to work above this limit of 48 hours. The Act also allows employees to have 11 hours rest in every 24 worked hours and a rest period of 24 hours in every 7 days. A 20-minute break when working more than 6 hours, and 4 weeks paid holiday each year. Disciplinary and dismissal procedures, otherwise known as DDP. These will cover how an employer should discipline or dismiss any employee. The employee must always have the right to appeal, and an appeal or grievance procedure must also be put in place.